Well, hello again, and welcome to our last BEERG Byte before we take a break for the month of August. I'm back talking to my old friends Vince Toman and David Hopper from Lewis Silkin. It's not that long since we spoke to the two of them, and that was because of the P&O Ferry dispute, which you will recall. P&O sacked its entire British-based crew and brought in agency crew to replace them, and it was a political storm, to say the least, with the government threatening all sorts of actions. So, Vince, what's been happening with P&O ferries, and what has the government been doing since we talked about this a month or two back?
Quite a bit, actually. The government put out a consultation paper, and they've now answered the question which they wanted to answer. So they asked themselves a question, and now they've got the answer that they wanted. And effectively, what they're saying is that there needs to be changes to the legislation. But it's not going to be a quick fix, because there's going to be need to change to primary legislation. So it's got to go through Parliament. And as since the last time we spoke, Boris Johnson is now an MP. Sorry, he's now the Prime Minister in name only, and has undertaken not to pass any legislation during that period of time. So there's going to be a slight delay in anything coming into force. But the essence is this, is that, as you know, when we discussed last time, the P&O ferries were that they left the UK port and went to France and then came back. But the legislation as drafted did not cover those under the national minimum wage legislation if you work on those ships. So what they've going to introduce now is that if the ship returns within a 72-hour period, then the operators and the ferry workers on those boats will be covered under the national minimum wage legislation. But there's a little glitch here, because it's the period of time in which they are in UK waters. So one can imagine if they kind of cross over a borderline, then are they then going to drop down onto lesser wages and then come back? My view is that they're going to get the whole period of time which they're engaged. But this, of course, has a knock-on effect for all of the boats now supplying ships in the North Sea, whereby is that they carry goods and supplies from a UK port out to oil rigs or wind farms and then come back. And if they return within a 72-hour period, they're also going to be caught. So it is going to increase costs for that type of operator. But the more strangest bit about this, they're going to invent a new post whereby someone is going to become responsible for making sure that they're all complying with the national minimum wage. And as lawyers, and I think David might have been involved in some of this, as lawyers, we've always thought it a bit strange, is that you have Her Majesty's Revenue and Customs dealing with the national minimum wage, where effectively, and doing audits when they are short of staff to do other things. So they're going to invent this post whereby the harbour principal is going to be responsible to ensure that all vessels using that particular port are going to comply with the legislation. But we'll have to see what it looks like in the end. But in essence, that's what's going to happen, Tom.
That's a question. Are any ships actually sailing from the UK to France at the moment?
Well, we have taken back control of our borders, Tom, but unfortunately the French have taken back control of their borders, which has meant that whilst there are ships sailing, there isn't the people who thought they were going to be on that particular ship with 6 hours delay. And the Channel Tunnel there was a couple 21 hours they were in a queue waiting to board the shuttle to go to France. Well, that's a good way to start your holiday, isn't it?
So in other words, the French aren't doing what they're being told to do by the British government, and that's not helpful.
No, and that's exactly it. But of course, the French are entitled to take back control of their borders if they so wish.
Well, indeed, as we in France would say, may we. So, David, I mean, there's been other developments as well, because P&O was, at the time there was a sort of a confusion as to whether P&O was a hire and fire decision. And of course, it wasn't. It was a fire and go and hire a whole bunch of new people on an agency basis. So, tell me a little bit about what's been happening with this hire and fire stuff in the UK.
Sure, Tom. So, I mean, a number of things have happened quite recently. So, a few months ago, we saw ACAS publish some new guidance, which followed the government asking it to look into this situation. I think more significantly, though, the government has now, following the P&O situation, committed to actually publishing a statutory code of conduct. that will be relevant in, for example, any tribunal proceedings over a fire and rehire situation. What's interesting, though, is exactly as you say, the government committed to do this guidance on fire and rehire because of P&O, even though P&O wasn't actually a fire and rehire situation.
Can we just stop for a moment? Because, I mean, there'll be a lot of people maybe watching this who don't really understand what fire and rehire actually means in practice. So could you explain that?
Sure. So essentially, if you have a workforce which has got particular terms and conditions, so it might be they've got a particular generous overtime provision under their contracts. If an employer wants to remove that provision or to make any changes, such as to the rostering of hours, and the employers employees won't agree to that, or if it's their trade union collectively bargaining for them, the union won't agree to that change, the employer effectively is stuck. So it can't force through a change under the terms of that existing contract. So what the law does allow in some situations is an employer to essentially serve notice and bring that contract to an end. And then as a second step, offer new terms and conditions of employment to those same individuals, with those new terms including the different provision on, for example, pay or on the working hours. So essentially, it's a mechanism that an employer can try to use to change something over the wishes of its workforce. And a good example of that is actually the Tesco case, which we've just had. So in the last few weeks, the Court of Appeal has made quite a significant decision involving Tesco and the trade union Usdaw. And this really brings to life the situation. So certain Tesco employees had particularly generous rights to what was called retained pay. They had those rights because Tesco, about 15 years ago, had had opened some new sites, said that they wanted to keep hold of their existing employees. And so they said, for the lifetime of them working for Tesco under these contracts, those employees would benefit from this higher level of retained pay. Fast forward over a decade, Tesco wanted to get rid of that provision. Unsurprisingly, the employees refused to agree to that. So Tesco said what it wanted to do was fire them, so they would no longer be on their existing contracts, and then to offer them new terms and conditions, essentially the same contract, but without the retained pay provision. Now, why the Tesco example is so important is in an unprecedented move, the High Court at the start of the year actually granted an injunction to say that Tesco could not give notice to its employees to bring their existing contract to an end, following which it would then rehire them. And essentially the High Court said that when the collective bargaining took place over a decade ago, it was understood that Tesco would never be able to end those contracts to remove that term. Now that would be quite an extreme position, and it was on an extreme set of facts. But interestingly, the Court of Appeal has now overturned that High Court decision, and it came up with two important decisions, really. The first was that people looking at the situation and those negotiations objectively over a decade ago would never have understood Tesco to be saying we could never dismiss those employees for the purposes of removing this term. They said that if an observer was standing there watching those negotiations, they would say that there was no way that Tesco was intending that to be the outcome. And secondly, it said that even if that had been the intention at the time, it wouldn't be appropriate for there to be an injunction to stop Tesco acting in that way. The real reason for that being that breach of a court injunction is actually a criminal offence, it's a contempt of court, and therefore Tesco would be at risk essentially for the rest of these workers' working lives if it ever tried to get rid of them, for example, in a redundancy situation. If it chose to dismiss them because they were more expensive, that would expose the business and managers, 15, 20 years in the future to the risk of actually a contempt of court. So the usual status quo has now come back into force. So you can't get an injunction to stop a fire and rehire exercise, subject to one final caveat here, which is that the union Usdaw has now said it's going to go to the Supreme Court and ask for permission to appeal this. So we'll obviously update people as and when we have a final decision on that.
But tell me, in these hire and fire situations, why don't the union just call a strike?
They could do. I mean, the issue that I think that Usdaw would have faced on this particular occasion is that it was only a very small number of individuals who had these terms. The real value to Tesco of these individuals was after they opened the new site just over a decade ago to make sure that the sites would be functioning and operational from the outset. If you fast forward on over a decade, the number of employees involved, I think it was around 40, so a very small number of employees. Even if Usdaw had called a strike and called those of its members out on strike, how much impact would that actually have had on Tesco, I think is questionable. So it was a very, and as the High Court said, it was an exceptional set of circumstances. But I think the principle is that you can't get an injunction for a fire and rehire to stop a fire and rehire exercise.
So I might just bring Vince back in on this, but I mean, doesn't this sort of suggest that the trade unions really in the UK don't have any economic leverage, full stop, and they desperately are trying to use the law to compensate for that lack of economic leverage?
I wouldn't use the Tesco situation as an example of that, because if we look at what's happening within the rail sector, we've got a strike tomorrow. We've had previous strikes. So I think in the public sector there is an appetite for something for industrial action, and so I don't think there is no leverage. I think that I found strange about the Tesco situation is that in the case of American Salmon, which is the leading case on injunctions, is the first thing you've got to look at is whether compensation is a suitable remedy, and clearly compensation in this case was a suitable remedy. There's only one class of employees I can think of who get injunctions, and that's head teachers, to stop them being fired by governors, because the damage to their reputation, if they don't get an injunction, is so severe that they never work again. So I'm a bit strange that the High Court actually ever awarded an injunction in the first place. But to your point, Tom, yes, I mean, unions are using the law more, and that is partly why union membership in the UK is decreasing, is because employees, in particularly individual employees, have the option to seek legal redress in the courts to protect their position, and maybe don't need a union and the subscriptions to do so.
Speaking of strikes, David, I mean, the UK is slightly unusual in the sort of procedural steps a union has to go through in order to be able to call a strike. Did I see recently that there's been some moves as well to subject the union to even more financial penalties if they don't go through the procedures correctly?
Absolutely. So in the UK, there is an ability for trade unions to call on their members to take industrial action, but there's a whole series of steps that they need to go through in order for it to be what we call protected industrial action. And in summary, that would be notifying the employer that there's going to be a ballot, giving a sample ballot paper, allowing the members to vote in a fair and secret manner, and then notifying the employer both of the result, but also then giving it due notice of the industrial action itself. And essentially, if the union doesn't follow all these steps, the action is unprotected. And importantly, what that means is an employer could then sue the trade union for its losses of the unprotected industrial action that the trade union might cause. So the government has actually, only with effect from last week, now changed the law. Parliament voted on it over the last few weeks. And so the maximum penalty, because there are caps on how much an employer can recover, the maximum penalty has now gone up to £1 million. Now, just as two bits of context on this, Tom, which I think are really important. The first is that actually the number of times you would see a business actually suing the trade union for this is extremely rare. The reason for that is that in normal situations, the real remedy for an employer in this situation is actually an injunction to stop the strike going ahead at all. You know, that's the real thing that an employer will want to secure, to stop the industrial action, which obviously then means there'd be no loss for them to go after. And secondly, I think it's quite interesting that the government's picked out the number of £1 million. Now, as a bit of context, the numbers hadn't increased for around 40 years. So that is actually sort of linked to the inflation increase. But I do think that this also ties in with sort of a more general sense that the government's coming out with at the moment of wanting to grab attention against the current backdrop of industrial action that Vince was mentioning, as opposed to this really being a significant issue that we're going to see playing through the courts on a day-to-day basis.
I've also seen in the last week or two that the government is moving to allow employers to bring in agency workers to replace people who are on strike. Is that all part of the same sort of performance? You know, look at what we're doing.
Yeah, I mean, this is slightly more significant, but just on the point that David, I'm old enough to remember that in 1982, two trade unions, the NGA and SOGAT, both fell foul of this piece of legislation, and both had to pay substantial damages. And effectively, SOGAT closed down and they opened up again as SOGAT 82, and that's what is significant about the date. So they're very rare, that type of thing. You're absolutely
But you're old enough, Vince, to remember when the 1906 Trade Dispute Act was gone through Parliament, aren't you?
Well, I'm old enough to remember that David's just said about all the legislation. I'm old enough to remember when I worked for British Nuclear Fuels, is on a Friday afternoon doing this, and we all went out on strike, which is a far cry from the procedural requirements now due. So things do change in time. But going to the agency workers, I think this is this is window dressing. We have 1.3 million vacancies in the UK. If there were all these agency workers sitting on their hands, waiting to take on activities of strikers, then surely they would apply for one of the 1.3 million things. And the second thing is if the real worry is about train drivers and is about teachers and is about nurses and doctors, my understanding is you need a qualification to do all of those particular roles and tasks. And I can't see many agency workers, again, sitting around waiting. Well, I'm waiting for a strike because I'm a doctor or I'm a nurse or a teacher. I'm waiting for a strike so that I can work for 3 weeks as an agency worker on behalf of the business. But it's to give the impression, Tom, that there is a solution to the cost of living crisis that we're going through. And the solution is to somehow undermine the trade unions.
Did I see, Vince, that one of the major trade unions has launched a legal challenge to this?
Yeah, it's Unison, which is a public sector worker union, effectively, has launched a challenge. Because first of all, to say is that it needs to go through Parliament. It needs to have parliamentary scrutiny. They're relying upon a study, and I think this is right, David, a study that occurred five years ago, and they're basically saying that their information is out of date, so they're not making a reasonable decision based upon reasonable information. So they're seeking a judicial review of this piece, this change in the legislation.
Just to add on that. So, I mean, essentially the government, because this, again, nothing is ever new. So this was an idea that the government previously had when it passed the Trade Union Act back in 2016. And there were studies done, as Vince says, around that time. And so the legislation under which these regulations has been made says that there needs to be a consultation. So the question is it out of date? As importantly, though, the unions are also pushing back on this on the basis that it would breach employees' human rights and effectively the right to take strike action, on the basis that if an employer can simply go out and hire agency workers to cover for them, it fatally undermines being able to go on strike. So that's sort of a second quite legalistic basis that we expect to see challenges.
I think I've seen some arguments as well that it could be in breach of the UK-EU Trade and Cooperation Agreement on the grounds that it's interfering with the level playing field on social rights. But I think that's punting it out there fairly far on that one, you know. Yeah. And was there not a sort of another decision, Vince? I think it's referred to as Mercer.
Yeah.
Now, something to do with sort of you can take away rights from people who are on strike. What's that got to do with?
Well, we've always had this orthodoxy view in the UK is that you got protection from not being dismissed whilst taking part in industrial action. Okay, so any action that was short of not being dismissed was permissible. And one of the things we talked about last time, Tom, if you may remember, was talking about peace payments, that we kind of offer people an incentive not to get involved in industrial action. And that was not seen to be a breach of other legislation, such as giving an incentive to give up your trade union duties and activities. Because whilst taking part in industrial action, you got the right not to be dismissed, but everything else went out the window. Now, what Mercer basically said is extended the period of time, which was the taking part in trade union duties and activities was significantly extended to cover strike. And we all had to go and sort of lie down in a darkened room because effectively it undermined the ability to incentivize people to continue with production whilst you were making fundamental changes. And both David and I have done this and advised clients on this many times. So Mercer was decided and then went up to the Court of Appeal. And what the Court of Appeal said is that the UK legislation is clear as to what, at the appropriate time is, i.e., so if you're on a strike, the employer is entitled to take other action. other than to dismiss you because that's already got covered under the legislation. But what the Court of Appeal also said, which is more of a worry, is that it also said is that the fact that it's for Parliament to make the decision, and bearing in mind what we've been talking about earlier on as to the drift or the drift in which Parliament seems to be heading after the leadership election, and it's not to give trade unionists more rights, is that the Supreme Court could come up with a conclusion is that whilst the Court of Appeal said that the legislation complied with UK law, it did not comply with the European Convention on Human Rights, and in particular Article 11. But that was for Parliament to make a decision to correct that defect. Now, the Supreme Court may make a determination on that, but I cannot see Parliament basically saying that that's right. But more importantly, if the Supreme Court do make that decision, Parliament living with the Supreme Court's decision.
Okay. The other thing, we talked a while back about another important, again, I come back to this, everything in the UK now around labour relations seems to hinge on court decisions, and we talked about the Costal decision, where an employer had made an offer and the Supreme Court said, yeah, but you made the offer before collective bargaining was exhausted. And there was another twist in that particular tale a little while back with ENOS, and I think you had said to me at the time, David, that there appears to be some discrepancy now between ENOS and some other decision. What was it, Scottish Borders or something like that? I remember, Vince, I'm as old as you, and I remember the days when labour relations were fairly easy. You went in and you made a demand, and if the employer didn't agree, you went on strike. Now you need to be a barrister, really, don't you?
Yeah, I think the world's definitely getting complicated. Let's put it that way, Tom. So, and unfortunately, this sums up the situation. So, exactly as you say, the Costal decision by the Supreme Court late last year is, on its face, very clear. An employer cannot make offers directly to its employees to effectively circumvent collective bargaining until the collective bargaining process with the union has come to an end and been exhausted. The rationale for that is until the process has been exhausted, you don't know if collective bargaining would have succeeded. Last year, before the Costal case, the Employment Appeal Tribunal made a decision that said that if you make a unilateral change to employees' terms and conditions, so effectively you try and force it through as a breach of contract, that does not amount to an offer. So if you simply do it, the employees are not accepting an offer from the employer for the purposes of the relevant legislation. The employer is clearly in breach of contract, but the way that the employees could get redress for it would be to bring a breach of contract claim. The INEOS decision, which doesn't actually refer to the Scottish Borders decision, seemingly conflicts with that outcome. And the reason it seemingly conflicts with that outcome is it says what the employees are then accepting if they allow the change to go ahead is not actually the breach of contract, which is what Scottish Borders said they'd be accepting. They are in fact accepting an offer which puts the employer in breach of the legal prohibition. And to put it into context, we're talking about £4,500 or so per offer per employee. Why is this relevant at the moment? It's relevant at the moment because many businesses are really struggling to get pay rises agreed at the moment with the trade unions because of the backdrop of cost of living and inflation we're seeing. And what a number of employers are trying to do is to say, well, can't we give some kind of money to our employees because we want to help them out in advance of gas bills going up in the autumn and so on. And essentially, these decisions conflict on whether an employer doing something unilaterally would actually be a breach of the relevant legislation. So I think for now, employers are probably advised to be quite cautious in how they approach this, purely on the basis that if you're only talking about, say £1,000 or a £2,000 cost of living allowance, well, actually you end up risking giving that money and then being hit with another fine for £4,500 per employee, which clearly changes the whole dynamic. So unfortunately, it's a watch this space, but I think employers should be quite cautious at this time.
Okay, well, look, there's an awful lot going on here. Maybe sort of we should come back together in September and maybe run a webinar on this and let people come in with questions because, so let's think about that. But before we wrap this up, can I ask both of you guys a question? At the moment, there are two intellectual titans struggling for the leadership of the Tory party, and therefore they'll become Prime Minister, right? And I see today that one of them has said that she's going to make the taking of industrial action even more difficult than it already is. Where do you guys think this stuff is going to go?
Shall I go first, David?
Go ahead.
Well, seeing as how you're an intellectual titan yourself, you know. I mean,
well, first of all, is I didn't recognise the description of the two candidates in the election, but putting that to one side, there is a piece of legislation which says that the court can't compel someone to come to work and to work for an employer, and I jokingly said to someone, well, Lord Wilberforce did away with that because he fought against slavery. So the idea that you can't withdraw your labour strikes me as being nonsense. And to some extent, is if you ever want a rallying call to actually to gee up the trade union movement and to rise it from its slumber, is to come out with this, that the idea that you can't go on strike. But what they're actually she's saying is you've got to have this minimum amount of service. Well, you're undermining the very strike that you're trying to do if you carry on working, but whilst taking the strike action. But what are you going to do, Tom? Are they going to criminalize everybody who kind of doesn't come along? Are they going to get the trade union are they going to fine the trade union, as David says, £1 million is because it's not providing a minimum level of service whilst its members are out on strike? I mean, this is a field day for lawyers. I mean, you know, it's a win-win for us if this comes in, because it is so unworkable. It is so unworkable.
You must be sorry that you're semi-retired.
I still have a number of fingers in a particular number of pies, Thomas.
Oh, well, I've seen the size of your yacht down in Marbella. Anyway, David, what's your view on all of this?
Personally, I think the government's going to really struggle. I mean, you'll be shocked to hear this, Tom. I think it's politics in the context of a leadership election rather than actually what we're going to see coming through on legislation. In slightly more detail, though, it was in the Conservative Party manifesto back in 2019 that they would introduce minimum service levels in the transport sector. So I think in particular on the railways, I can therefore see that going through Parliament. I think it will be challenged, but in the courts there's a breach of human rights legislation and so on. And I think it was Russia has had some cases at the European Court before it got kicked out as a result of the war over minimum service levels. So I can see that going through, because I think the House of Lords will let that go through and become legislation, because it was actually a manifesto commitment. What Liz Truss has also come out with, though, is, for example, raising the thresholds of people voting in favour of strike action for trade unions being able to go on strike across the whole sector, all sectors of the economy. Personally, I simply do not see that going through the House of Lords. And I think the House of Lords would, in quite a pointed way, allow the bit that was in the manifesto through and say the rest of it, you need to go back to the country in another manifesto. So I think something will go through. I think in practice, the impact of it will be relatively limited, because we're now coming off the back of COVID. So if you have a train strike, of course, there is disruption for many people. Many people can't work from home, but the days of it bringing the country to a standstill in quite the way that it would have done pre-COVID are over. But I really see this as politics. I think they will introduce the legislation quite early on, and both candidates have said they'll do it. But I don't think it's actually going to be sort of revolutionary in terms of how industrial relations will play out in the country.
Okay, so look, I can't finish up this without asking you, David, one last question. Any updates on European Works Council cases going through the courts in the UK, or is it as it was? As
it was. So just as a quick reminder on that, so there's an appeal going on in the autumn, which is now being listed. The government's intervening in that case. That's taking place in the autumn, and it effectively will decide whether or not they need to be UK-based European Works Councils. Given the hearing date, we'd hope to have a decision by the end of the year at the very latest, and of course we'll update people as soon as we have it.
Okay, well look, let's do what I just suggested a few minutes ago, come back and have a further conversation around all of these issues sometime in September, and we'll open it out at that time and sort of to members who want to participate in the webinar and ask you guys some questions. But look, as usual, a pleasure talking to both of you. Thank God it's only a week to go to the start of the football season. We might make some progress this year. But anyway, listen, always a pleasure to talk to you two guys. We'll talk again in September, and no doubt we'll see one or both of you at our meeting in Brussels at the back end of September. So until then, appreciate it. Thanks a lot.
Thanks, Tom.
Bye, Tom.